Here now to break all this down, Fox News legal analyst Gregg Jarrett. Great to have you on for this, Greg. So first of all, break down what the Supreme Court ruling means.
Look, Article 2 of the Constitution gives the president broad power over foreign affairs and international commerce, and tariffs qualify as both. On top of that, Congress delegated specific authority under the Emergency Powers Act to regulate imports, which obviously includes tariffs, Charlie. But, the majority today ignored all of that and decided to draw this imaginary distinction saying, well, the act doesn't actually use the word tariffs. Well, they're playing word games. They're twisting the plain meaning of that important phrase, regulate imports. That's a comprehensive term, and of course it means tariffs, as well as duties, and license fees, and limits on imported goods, all of those things.
Think about a primary school classroom. Think about the small plastic bears used to teach counting. Think about the magnets on the whiteboard or the colorful blocks on the carpet. These are simple tools. They are the resources teachers use every day to help children understand the world. They are durable, they are familiar, and they are usually the last thing you would associate with a national emergency. But in early 2025, these simple classroom resources became the center of a multi-billion-dollar legal battle over the very definition of American power. Let's play this clip. Think about a primary school classroom. Think about the small plastic bears used to teach counting. Think about the magnets on the whiteboard or the colorful blocks on the carpet. These are simple tools. They are the resources teachers use every day to help children understand the world. They are durable, they are familiar, and they are usually the last thing you would associate with a national emergency. But in early 2025, these simple classroom resources became the center of a multi-billion-dollar legal battle over the very definition of American power. Let's play this clip.
As taxes, Congress, the argument goes, Congress must initiate and be responsible for levying all taxes. But, the reason the founders wanted that is because taxes are things that are levied on citizens, their bosses back home. That's why the House originates all tax bills, because they wanted the legislature that was closest to the people to be the ones originating taxes. This is something that is levied not by the bosses of Congress, but by foreign entities. I don't really understand why everyone just accepts this notion that taxes are tariffs.
The word for these classroom tools is resources. It is a word that suggests something helpful, something foundational. But in the world of high-stakes federal law, resources take on a much heavier meaning. Resources are the wealth of a nation. They are the manufacturing base, the critical supply chains, and the vast flow of goods moving across our borders. When a government decides its resources are under threat, it doesn't just look for new tools, it looks for new powers. It looks for ways to reach into the pockets of the people who make and buy those plastic bears.
Well, it's an excellent point. And, if you heard the oral arguments, the justices struggled over that and disagreed with each other. But look, the White House will replace or replicate the equivalent tariffs, this time under 3 different trade acts passed by Congress that explicitly give the president tariff authority. They use that word tariffs. For example, under 301, he can impose tariffs to counter anything from unfair trade practices, injury to our domestic industry, balance of payment deficits. 2 other trade acts empower him to punish countries that discriminate against the U.S. or threaten our national security, which some do. So, Trump's power to use tariffs remains the same. The revenue, said the Secretary of Treasury, will remain unchanged. And as for, the billions in refunds, well, Trump has enormous leverage. He can say to foreign importers, you better waive your refund demand or I'll invoke more severe tariffs. Don't forget, Trump is the consummate negotiator, and he is more than capable of driving hard bargains, Charlie.
Yes, indeed. It will be a fun couple of weeks to watch this play out.
In February 2026, the United States Supreme Court handed down a landmark decision in a case titled Learning Resources, Inc. versus Trump. It was a case about educational toys, but it was really about the core congressional power of the purse. It was about whether a single word in a 1977 law could authorize a president to unilaterally change the price of every single thing coming into this country. This is the story of how a toy company in Illinois and a wine importer in New York forced a reckoning over who actually runs the American economy. The pattern began with a series of actions taken in the opening days of a new administration. It started with the declaration of a national emergency. Two emergencies, actually. One focused on the influx of illegal drugs from Canada, Mexico, and China. The other focused on large and persistent trade deficits that the president determined had led to the hollowing out of the American manufacturing base. The president invoked a law from 1977 called the International Emergency Economic Powers Act, or IEEPA. He used it to do something no president had done in the half-century since that law was passed. He imposed tariffs. The pattern spread rapidly across the map. In Vernon Hills, Illinois, Learning Resources and its sister company, Hand to Mind, two family-owned manufacturers of educational toys, watched their costs skyrocket. They reported a 44-fold increase in costs related to these new duties. In New York, at a wine importer called VOS Selections, the story was the same. Small businesses, a pipe maker, a fishing gear shop, found themselves facing potential bankruptcy. Then the states joined in. 12 states, led by Oregon, filed suit. They weren't just arguing about toy bears or bottles of wine. They were arguing that the president had checked the wrong statutory box. Let's play this clip. If you look at the evidence, the scale of these actions was unprecedented. It wasn't just one tariff, it was an escalating stack of executive orders. On February 2nd, 2025, the president issued executive orders 14193, 14194, and 14195. These imposed a 25% duty on most imports from Canada and Mexico, and a 10% duty on most Chinese imports. But that was just the baseline. 1 month later, Executive Order 14228 increased the China rate to 20%. 1 month after that, Executive Order 114256 removed a long-standing statutory exemption for goods worth less than $800. Then came April 2nd, 2025, Liberation Day. The president issued Executive Order 14257, declaring a global economic emergency. He imposed a reciprocal tariff of at least 10% on all imports from all trading partners. Dozens of nations faced even higher rates. 6 days later, Order 14259 jumped the rate on Chinese goods from 34% to 84%. The very next day, Order 14266 pushed it to 125%. When you added it all up, the total effective tariff rate on most Chinese goods hit 145%. The government boasted that these tariffs would reduce the national deficit by $4 trillion. They claimed that international agreements reached in reliance on these tariffs were worth $15 trillion. By September 2025, the Treasury had already collected an estimated $90 billion. The scale shift here is what makes it a Supreme Court case. It moves from a local toy manufacturer in Illinois to a national trade policy that touches every consumer, and finally to the fundamental institutions of our government. The question wasn't just whether the tariffs were a good idea. The question was whether IEEPA, a law that allows the president to regulate importation during an emergency, actually gives him the power to tax. The government argued that the power to regulate is broad enough to include tariffs. They argued that because the president can block an import entirely with an embargo, he must have the lesser power to charge a fee for it. But the Supreme Court's majority, led by Chief Justice John Roberts, looked at this through the lens of history. They reached back to the very beginning of the Republic to find a parallel for what was happening in 2026. They went back to 1789, to the first Congress. They noted that the second law ever enacted by that Congress was a tariff law. The framers, having just fought a revolution over taxation without representation, were obsessed with the power of the purse. They gave that power to Congress alone. In Federalist Number 48, James Madison explained that only the House of Representatives should have access to the pockets of the people. The court pointed to another historical parallel from 1791. General St. Clair had been defeated in the Northwest Indian War. President Washington needed to expand the army. He needed revenue. But even in that moment of crisis, there was a fierce debate in the House about whether they could even ask the Secretary of the Treasury, Alexander Hamilton, for advice on raising money through tariffs. They were worried that even asking for advice might infringe on the legislative power to tax. The court's point was clear. The power to impose tariffs has always been seen as a sacred legislative act. This brings us to the human authorities who debated this case in the public eye. Gregg Jarrett, a Fox News legal analyst, offered a sharp critique of the ruling. He argued that the court was playing word games and twisting the meaning of regulate imports. Jarrett contended that tariffs are a comprehensive term and clearly fall under the president's authority to manage international commerce. He suggested that Chief Justice Roberts was more concerned with the precious reputation of the court and his own legacy than with fidelity to the law. On the other side, you had legal scholars like Michael McConnell, who argued that the power to tax cannot drift silently into the hands of the president through inertia or creative readings of statutes. Inside the courtroom, the debate turned on something called the Major Questions Doctrine. This is a legal principle that says if an executive agency or the president wants to exercise a power of vast economic and political significance, they must point to clear congressional authorization. They can't just find it lurking in ambiguous statutory text. Chief Justice Roberts wrote that if Congress wanted to pawn off such a big-time policy call to the president, they wouldn't have done it using a single word like regulate. He noted that in the half-century since IEEPA was passed, no president had ever used it to impose a tariff. That lack of historical precedent, he said, was a telling indication that the power didn't exist. Justice Neil Gorsuch, in a powerful concurrence, expanded on this. He argued that the Major Questions Doctrine isn't some magical innovation. He traced it back to the common law of corporations and the law of agency. He said that when a principal, in this case Congress, delegates power to an agent, the president, the agent must stick to the usual manner of doing business. He noted that men are not angels, and resourceful members of the executive branch will always have an incentive to exploit loose language to assume new power. Gorsuch warned that once a power is given away, it is almost impossible for Congress to retrieve it, because any president would likely veto a law trying to take it back. The court also looked at the technical language of the law. IEEPA lists 9 verbs that describe what a president can do: investigate, block, regulate, direct, compel, nullify, void, prevent, or prohibit. It lists 11 objects those verbs can apply to, creating 99 possible combinations of action. Not one of those combinations mentioned the words tariff, duty, or tax. Justice Elena Kagan, joined by the liberal wing of the court, agreed with the result, but for different reasons. She didn't think the court needed the Major Questions Doctrine. She said straight-up statutory construction was enough. She pointed out that in the hundreds of places where the word regulate appears in the U.S. Code, the government couldn't find a single one that was understood to grant the power to tax. There was also a constitutional trap in the government's argument. IEEPA allows the president to regulate importation or exportation, but the Constitution explicitly forbids taxing exports. The court reasoned that if the word regulate included the power to tax, then IEEPA would be partially unconstitutional because it would give the president the power to tax exports. To avoid that result, the court concluded that regulate simply doesn't mean tax. The dissent, led by Justice Brett Kavanaugh and joined by Justices Thomas and Alito, argued that the majority was being too formalistic. Kavanaugh pointed to the wartime history of the presidency. He cited President Polk during the Mexican-American War, President Lincoln during the Civil War, and President McKinley during the Spanish-American War. In all those cases, the presidents used their war powers to impose duties. He argued that when Congress passed IEEPA, they were essentially codifying these traditional tools for use in emergencies. He cited a 1976 case called Algonquin, where a unanimous Supreme Court allowed President Ford to impose license fees on oil imports under a law that let him adjust imports. Kavanaugh argued that if adjust includes fees, then regulate must include tariffs. However, the majority held firm. They ruled that while taxes can be used for regulatory ends, the power to regulate does not automatically include the power to tax. They noted that whenever Congress actually wants to delegate tariff power, it does so with extreme specificity. They use words like duty. They set 15% or 50% caps. They set 150-day time limits. They require investigations by the International Trade Commission. IEEPA had none of these limits. If the president's reading were correct, he could escape all the rigors of the actual tariff laws by simply declaring an emergency that never ends. So, what changes because of this ruling, and what stays the same? In the quiet aftermath of the February 20th decision, the IEEPA tariffs were struck down. The $90 billion collected became a legal mess. Court observers noted that when tariffs are invalidated, the government generally cannot lawfully retain that money. But the policy goal didn't disappear. Within hours of the Supreme Court's loss, the president announced a new plan. He shifted to a different law. Section 122 of the Trade Act of 1974. He imposed a 10% global tariff, which he quickly increased to 15%. This new move followed the rules the court had just clarified. Section 122 explicitly allows for an import surcharge, but it also has a hard 150-day limit. It requires Congress to vote if it's going to be extended. It is a more narrow power, and it keeps the branches in their respective lanes. The 145% rates on China were gone, replaced by the 15% maximum allowed under the other statute. The Liberation Day framework was effectively dismantled and rebuilt under a different legal authority. This matters quietly because it affirms a fundamental norm of the American system. The Supreme Court reminded the executive branch that it is not a monarch and that even in an emergency, the birthright power to tax remains with the people's representatives. It affirmed that the deliberative nature of the legislative process is the point of the design. It ensures that laws must earn broad support to survive, allowing ordinary people and toy manufacturers in Illinois to plan their lives without the rules shifting overnight based on a single word in a 50-year-old law. The count of plastic bears in a classroom remains a simple task for a child, but the counting of the resources that bring those bears to the classroom remains, by order of the highest court, a task for the collective wisdom of Congress, not the unrestricted judgment of a single office. What changes is the legal box the president must check. What stays the same is the ongoing debate over how to protect the American manufacturing base, and why it matters quietly is because it proves that in a republic, the words in the law must actually mean what they say, even when the pressure of an emergency is pushing for them to mean something more. The legal analyst Gregg Jarrett noted that presidents have historically won these cases when they rely on other statutes like Section 338 of the 1930 Tariff Act. The administration has signaled it will continue to use every tool available, from Section 232 for national security on steel and aluminum to Section 301 for unfair trade practices. The lawfare, as Jarrett calls it, will continue. Each new executive order will likely face a new round of lawsuits from adversaries who run to the nearest favorable venue. Senator Josh Hawley has even introduced a bill to place limits on activist judges who issue universal injunctions against the president's agenda. But for the moment, the Supreme Court has cleared up the specific drama of IEEPA. They held that emergency powers tend to kindle emergencies. They noted that some IEEPA emergencies, like the one from the Iranian hostage crisis, have been ongoing for 4 decades. They warned that emergencies can afford a ready pretext for usurpation of congressional power. By striking down the tariffs, they didn't just rule on a trade policy. They reinforced the wall between the branch that spends and taxes and the branch that executes the law. The winery in New York and the toy maker in Illinois may see some relief from the 145% rates, even as they adjust to the new 15% surcharge. The global trade agreements facilitate trillion-dollar deals, but they must now stand on a different statutory foundation. The Treasury might have to figure out how to refund billions, a process that will be, in the words of the solicitors, a mess. But the big-time policy calls are back in the legislative arena. The pockets of the people are, for now, guarded by the requirement of a clear statement from their elected representatives. In his concurring opinion, Justice Gorsuch offered a final reflection on the virtues of this slow, difficult process. He admitted that legislating is hard and takes time. He acknowledged it is tempting to bypass Congress when a pressing problem arises. But he argued that the legislative process helps ensure that each citizen has a stake in the laws that govern us. It prevents the permanent accretion of power in the hands of one man. For some, he said, the disappointment of the ruling will be great, but history suggests that the tables will turn, and one day, those who are disappointed today will appreciate the legislative process for the bulwark of liberty it is. The classroom resources remain on the carpet. The counting bears are still there. The magnets still stick to the board. They are small things, but they represent a vast economy that the Supreme Court has ruled cannot be governed by oblique or cryptic interpretations of the law. The power to tax and the power to regulate remain entirely distinct, just as Chief Justice Marshall said they were in 1824. And as the administration pivots to Section 122 and Section 338, the institutions of the Republic continue their long, deliberative work of defining the limits of power in a complex and changing world. The final word on this case wasn't just about money or trade deficits. It was about the constitutional structure that requires the government to act with due deliberation. It was a reminder that even the most potent economic weapons must be used within the lanes assigned by the Constitution. As the 15% tariffs take effect and the 150-day clock begins to tick, the burden of proof has shifted back to Congress to decide if these measures should endure. The clown chaos some critics described and the brilliant negotiating others praised have both been funneled back through the constitutional filter of the three branches of government. What stays is the law. What changes is the exercise of it. And what matters is that the Supreme Court decided that some powers are too extraordinary to be found in the silence of a statute. The counting continues, but the rules for how we count our resources have been reaffirmed. The major questions have been answered with a demand for clarity, ensuring that the national fabric remains based on the one great power of the people's representatives to control the purse. As the administration explores how to keep its trade strategy alive through other acts, the legacy of the learning resources case will be its refusal to let the president unilaterally impose tariffs of unlimited amount, duration, and scope. It is a landmark rebuke of a signature policy, not because the court disagreed with the goal, but because it insisted on the limited role assigned to us by Article 3. The case is remanding, the orders are vacating, and the Republic is, in its own episodic and rare way, holding its ground. The Fox News analysts will continue to debate whether the court was gutless or fiducial. The lobbyists will continue to seek relief for small businesses. The world leaders will continue to watch the American trade landscape with concern. But the Supreme Court has issued its reminder. The president is not a king, and the power to tax is not a word game. It is a birthright of the legislature, and it requires a clear, explicit, and limited grant of authority to be exercised by any other branch. The plastic bears in the primary school classroom are safe from the 145% tax for now. The wine in the cellar in New York is subject to a 15% surcharge instead of a bankruptcy-inducing duty. The trade deals with Japan and the European Union must be reevaluated. And the federal debt, that $37 trillion figure, will have to be addressed through the One Big Beautiful Bill or other legislative acts, rather than through creative readings of the IEEPA. The Liberation Day tariffs have met their match in the Major Questions Doctrine, and the resulting uncertainty is the price of maintaining the separation of powers in a 250-year-old democracy. The script for the next 4 years is still being written, and it will involve more executive orders, more proclamations, and more challenges in preferable venues. But the Supreme Court has set the stage. They have said that emergency powers tend to kindle emergencies, and that the super president model has its limits. The institutions have spoken, the precedents have been cited, and the resources of the nation remain, as they should be, a matter of public law and shared governance. The story of learning resources versus Trump ends with a remand and a dismissal for lack of jurisdiction in one court, and an affirmation of a permanent injunction in another. It ends with the president raging on social media and then immediately finding a new, more legally sound path. It ends with the precious reputation of the court intact in the eyes of some and corrupted in the eyes of others. But most importantly, it ends with a clear statement that in the United States, the power to regulate importation does not mean the power to tax the American people without a clear and specific vote from their representatives in Congress. This is the state of the law in 2026. This is the pattern of power, and this is why the simple counting bears in an Illinois classroom were the most important resources in the country for one pivotal week in February. The court has ruled, the president has pivoted, and the republic continues its difficult, noisy, and essential work of self-governance.